Ready? Start. The challenge in the present appeals is to the orders passed by the Armed Forces Tribunal, Regional Bench, Kochi on 26 October 2010 and April 12, 2011, holding that the respondent is entitled to service element of disability pension from the date of discharge. Full stop para. The facts in brief are that the applicant was discharged on 30th June 1978 after completion of 10 years and 169 days of service. Full stop. He was in low medical category since 1970. Full stop. He was granted disability pension at the rate of 50% on account of suffering from vital post discharge, but the applicant was denied the benefit of service element of disability pension. Full stop. It is the denial of this service element which led the applicant to invoke the jurisdiction of the tribunal. Full stop para. The stand of the appellants before the tribunal was that the applicant is not entitled to service element of disability pension as he was released on expiry of engagement before completion of pensionable qualifying service of 15 years and was not invalided out of service on account of disability, though he has been paid service gratuity and death-cum-retirement gratuity. Full stop para. The learned tribunal relied upon Regulation 101 of Navy (pension) Regulations 1964 to hold that since applicant has been invalidated from service on account of disability, therefore, he is entitled to full disability pension, including the service element. Full stop. The reliance was also placed upon Regulation 107 of the regulations, which contemplates that where the individual has not rendered sufficient service to qualify for service pension, the personnel will be entitled to proportion of the minimum service pension appropriate to the individual's ranks and group. Full stop. It is the said order passed by the tribunal which is the subject matter of challenge in the present appeals. Full stop para. Miss Diwan, learned additional Solicitor General for the appellants argued that the applicant was not boarded out of service on account of disability, but on account of completion of the engagement. Full stop. The learned additional Solicitor General traced the history of the grant of disability pension. Full stop. It is submitted that disability pension was initially granted when a member of the armed forces could not be retained in the force on account of disability, attributed to or aggravated by military service. Full stop. Such course was creating hardship to the personnel boarded out on account of injury suffered due to military service. Full stop. Therefore, the concept of disability pension was introduced. Full stop. The disability pension has two components, that is service element and the disability element. Full stop. The disability element is related to disability, whereas the service element is to be granted as per the rules and regulations applicable. Full stop. The qualification service for earning pension is 15 years, therefore, an individual who has not rendered 15 years of qualifying service and was not boarded out on account of disability is not entitled to service element of pension. Full stop para. It is argued that regulation 105B of the regulations would be applicable if an individual is not invalidated out of service on account of disability and has not opted for continuation in the armed forces. Full stop. The said regulation provides that on completion of period of engagement, apart from service, pension admissible which is on completion of 15 years of service, a disability element is also granted. Full stop para. It is argued that initially, the regulations contemplated 10 years of engagement with another 10 years as reservist. Full stop. Therefore, an individual would not be entitled to pension merely upon completion of 10 years of active service, but would become entitled to service pension upon completion of 15 years of service, including 5 years as reservist. Full stop. It is argued that such situation has undergone change when on 3rd July 1976 the Government of India contemplated 10 years as initial period of engagement with the option of re-engagement of the existing sailors on completion of 10 years of engagement. Full stop para. It is argued that the period of engagement in case of the applicant was 10 years approximately. Therefore, he has not completed the qualifying service of 15 years in terms of regulation 78 of the regulations. Full stop. Thus, he is not entitled to service element as the same is payable only after completion of 15 years other than to an individual who is boarded out from service on account of disability. Full stop. The reliance is placed upon a judgment of this court reported as T.S. Das and others versus Union of India and another